People v. Shaw?
Good afternoon, Your Honors. Cleo Weiss for Samuel Shaw. May I please reserve 3 minutes for rebuttal?
Yes.
Thank you. Before discussing attenuation and the voluntariness of the purported consent in this case, I'd like to start by addressing the SWAT team raid and the arrests and why my client's arrest was illegal, which the Fourth Department correctly held in this case.
Can we reach that issue?
You can. County Court did render a decision on that, and the Fourth Department was correct to review that decision.
Right, but you prevailed on that decision, right, and you're appealing? So
We did prevail on the issue of the Fourth Amendment violation in the Fourth Department. I was starting with that because I think the nature of the Fourth Amendment violation does inform the rest of the analysis. But
But do you think we can revisit the Payton determination below?
I think it's a mixed question of law and fact, and I think that there's record support for the Fourth Department's determination that Mr. Shaw was forced out of his house, therefore violating Payton.
So that sounds like a no in terms of our review.
I think this court should also find that there's a Fourth Amendment violation in this case, and I think that there are no impediments to this court's review.
I guess
of
Judge
that issue.
Garcia's question really is, you're not aggrieved by that part of the decision, right? And if you're not aggrieved, then, you would have to have a cross appeal for us to be able to reach the issue, which you don't, so we're stuck with that ruling, so you can move on if you like, I think, is what he's
And I
suggesting.
will. I know Mr. McCarthy
he was
does
arguing.
take issue with the Fourth Department even adjudicating that claim, but I think the Fourth Department was correct because county court did render a reviewable decision. And given that there is a Fourth Amendment violation, in this case, the main issue for me is that the people have never argued an exception to the exclusionary rule in this case. And this court has held that exceptions to the exclusionary rule, such as inevitable discovery, have to be argued and they have to be proven by the people. And in this case, Mr. Shaw in his motion papers identified the firearm as an unattenuated fruit of his illegal arrest. It's twice in his motion papers.
Yeah, but what the people are relying on is a voluntary consent, and they're basically saying that, for lack of a better word, trumps what was going on in terms of attenuation.
So I disagree with that because I think the case law makes clear, including this court's cases in Borges and Leroy M., that it has to be voluntary and it has to be attenuated. There's two separate analyses that have to be satisfied.
But it seems to me the appellate division, when I read their opinion and their cite to their other appellate division case, is saying a voluntary consent by a third party is per se attenuation in this case.
So I disagree with that, and I think that this court's
But
decision...
you disagree that they said that, or you disagree with the premise?
I disagree with their premise.
Right.
Yes, that is what the Fourth Department in this case held, that a voluntary
But it
consent...
seems to me that attenuation goes to what you were talking about first, which is fruit of the poisonous tree. And if I'm subject to an illegal arrest, the defendant subject to an illegal arrest, Payton violation, and that defendant gives consent, even if that consent is voluntary, it has to be attenuated from the Payton violation in order to sever that. This is a third party consenting. So why isn't the appellate division correct that voluntary consent, which the voluntariness may take into account the facts and circumstances of the Payton arrest as it affects a voluntariness, but why do you need a separate attenuation?
So a third party's consent can be a fruit of the defendant's, of a Fourth Amendment violation against the defendant. And we see that
Why?
because coming from Wong Sun directly, in which there's three
No, but
defendants
what
in
is
Wong
the
Sun.
logic in terms of fruit of the poisonous tree and suppression of having a third party consent be subject to that?
Because the law enforcement choosing to seek consent from a third party, which in these cases is often the wife or the girlfriend or the sister, is very much a part of the entire strategy, an entire law enforcement strategy of going to a home and seeking to arrest
Let's say
somebody
it was
at their
a
home.
different home, right? They do an illegal Payton arrest at this residence, and they simultaneously go to the defendant's other residence, and they get a roommate consent. Is that roommate's consent in residence 2 subject to attenuation from the Payton violation?
So I think it is, and in my brief, I cite State versus Lane, which is the
So
decision.
how would you analyze attenuation in my hypothetical?
So I would, in State versus Lane, the Iowa Supreme Court, I find it to be a very thorough and persuasive opinion. In that case, the defendant is legally arrested at his neighbor's garage. and they go down the street to his house where his girlfriend is present, and they seek consent from the girlfriend to search his house. And the Iowa Supreme Court goes on to analyze whether her consent is a fruit of the illegal arrest.
And how do they do that?
By looking at by applying the normal factors from Brown versus Illinois. The exact same attenuation
So
factors.
how much time it is between, let's assume she doesn't know, I don't know the facts of that case, but let's assume she doesn't know about the arrest at all. So you would still look at how close in time it was to the arrest that she knows nothing about?
So temporal proximity in that case would be perhaps a less important factor. but
What
you
are the
would-
important ones?
Sorry.
What are the important factors regarding attenuation in that circumstance?
Intervening circumstances, the flagrancy of the police conduct.
All
the
happening
fact-
at another place?
Well, in a case where there is a Fourth Amendment violation at one location and the officers go to a second location to seek consent, I think it is the people would have a strong argument that there is attenuation. These
So if-
factors go to,
Go ahead.
the factors go, I think, to the analysis, and that there might be a strong claim for the people that there is attenuation, but they do not say that there is per se.
So any investigative step they take at the same time they do a patent violation is subject to an attenuation analysis?
Anything that is a fruit of that patent violation or that.
So where,
That's circular, I think. We're
Yeah.
trying to figure out what the fruit is.
So when the
What's
def-
properly deemed a fruit.
The defendant claims something is the fruit of the arrest. That shifts the burden to the people under Borges.
Right, but where you have third-party consent, I understand that general proposition, but where you have third-party consent, are you saying that that framework doesn't shift at all? We consider it exactly the same?
I think that framework does not shift at all, and there are numerous federal courts of appeals and state courts that have held that it is the same analysis.
But why should that be, as a matter of logic? Why doesn't the fact that there is another actor involved somehow perhaps mitigate the attenuation concerns a little bit?
Having another actor involved does not per se take us out of an attenuation analysis. It does
I
affect
take that
it.
point, I'm just asking you whether it makes it, for example, easier for the people to show there was attenuation.
I think it would make it easier for the people to show attenuation when it is a third party.
Just to shift gears for a minute on voluntariness, I take it your argument is there's no record support for voluntariness findings. Okay, so in light of her testimony, how could that be the case? She testifies in a way that I think could perhaps be read to suggest that there's voluntary consent.
So her testimony is that she was not coerced into consenting and that she was not promised anything.
And not intimidated, I think she said, if I'm remembering the record correctly.
That's correct. And those three things, taking her testimony at face value and crediting it, those three things are not inconsistent with caving to overwhelming official pressure.
Yeah, but if the question is record support, then whether it's consistent or inconsistent may not get you across that line, right?
It may not, but I do think that this court could hold as a matter of law that when somebody has been subjected to a patent violation, handcuffed and removed from their own home, and while that Fourth Amendment violation is still ongoing because she's still in the car handcuffed when they elicit the consent from her.
No matter what the individual says under oath.
Right, when you're,
About their reaction.
when you've been subject to a stressful patent violation removed from your own home, that the consent to search
Yeah,
your
but
own home.
usually in those circumstances, that witness would be testifying for the defense to say that she felt coerced. I mean, in this case, she's testifying for the people and saying she didn't feel intimidated. That plus the testimony of the police officer who basically said she leapt for whatever, I don't know what he said, something like that, leapt for joy or hugged him or was happy that they would get a gun out of her house, and she was distressed when she found out that it was her friends who were murdered. I mean, how can we say that there's not record support for the court in those circumstances? She's testifying for the people and saying, no, it was voluntary.
You know, and I do recognize it's a mixed question of law and fact, and that is a difficult burden, but I think this court I think it would be an appropriate rule to hold as a matter of law that consent cannot be voluntary when you are giving consent to search the location out of which you've just been illegally removed.
And are you aware of other kinds of circumstances where we have held, I mean, usually it's a fact-specific analysis, right? You look at the record in front of you, and I hear you to be suggesting a blanket rule which says, you know, when a third party witnesses a patent violation, per se cannot be voluntary no matter what they experience or say they experience. So where else have we taken a bright line view like that? It seems unusual to me.
I think it would be, in the context of voluntariness, I'm not sure that this court has ever held something similar. So I understand that on that point, that would be a novel rule we'd be asking for this, from this court. But returning to the idea that the people's burden is both attenuation and voluntariness, putting aside voluntariness, which may be a mixed question of law and fact for which this court might find record support, that still leaves us with attenuation, which the people have not preserved. And they've not preserved it, nor do I think they could win on the merits, because it's that Ms. McCoy's consent is also a fruit of the patent violation. The search is illegal for that independently.
So
for that
regardless
reason.
of whether she was in handcuffs or not, your position is still that that consent was not properly attenuated from the illegal arrest of of your client?
That's correct, yes.
So the circumstances of the consent really have nothing to do with this, in your view?
Because I think looking at attenuation, and again, it's my position that the people have not preserved this contention, but when you look at attenuation, you are measuring from the Fourth Amendment violation to the consent itself. And I think that this is a really important issue because this court has said it both ways in different cases. In Banks, this court concludes, it concludes and analyzes the attenuation from violation to consent. But in matter of Leroy M. and Borges, the court considers the nature of the consent in that analysis. And in People versus Lane, there's an extended discussion of this, and I think there's also in footnote 3 of that decision, the court is analyzing the 10th Circuit Court of Appeals, which, like this court, had opinions analyzing attenuation in both ways. And the 10th Circuit corrects itself and in an eventual opinion and says, we want to clarify our former holdings and note that we measure between the violation and the consent itself. And I think that this court also has cases that analyze attenuation in both ways, and this case would be an appropriate case to clarify that what we look at is what is attenuated from the violation to the giving of the consent, and the nature of the consent actually doesn't come into that determination. And the reason for that is that when you're looking at the evidence that's seized, it is not different from the consent, which is the search, giving consent to do the search that gets that
Well,
evidence.
I think in Lane, and I'm looking at page 386, the court is saying, thus, if the circumstances show the initial questioning, or in this case, the consent, was given with detached reflection and a desire to be cooperative, it indicates the presence of intervening circumstances that break the causal chain. So why isn't that what happened here?
So in Lane, what the Supreme Court of Iowa ultimately concludes is that they only want to look at, they're measuring the girlfriend's consent in their separate home, whether it's attenuated from the violation. And they do look at the nature of her consent in their voluntariness analysis, which they do separately. But as to the attenuation analysis, they do stop it upon the asking for consent, is my recollection of that case.
It sounds like you're saying the attenuation analysis in this type of circumstance and maybe anything other than the one that was the subject of the prior hypothetical is really just time dependent, or is it more than time?
It's more than time. It looks at the Brown versus Illinois factors of temporal proximity, intervening circumstances, and flagrancy and purpose of the police conduct.
Okay, so if we have intervening circumstances such as, new information about the crime that took place, the shooting that took place, which suggests a different motivation for the consent, would that be the proper subject of an attenuation analysis, or does that go to the consent?
I think it can be considered, and that could be weighed against the fact that she's still handcuffed in the back of a police car. Lieutenant Zenilovich testifies she's not free to leave, so she's illegally detained. I think
Do you
that
think the record's clear on that? That is she handcuffed at the time of consent? I thought the record was ambiguous on that question.
her testimony is clear that she's still handcuffed in the car at that time, and that after she gives consent is when they let her come out of the car, and they unhandcuff her in order for her to sign that form.
So you read it as her giving verbal consent in the car and then being uncuffed to sign the form outside the car?
Yeah, I think that's established by her testimony. Thank you.
Thank you.
Good afternoon, Marty McCarthy for the People. The question of Peyton is unpreserved for this court's review.
Can I ask you to start by telling us your response to the argument about whether you preserved attenuation, and if so, how and where?
To answer that question, I would have to talk about Peyton.
Okay.
And the reason why there is no discussion of attenuation at the hearing level is the hearing court summarily denied the Peyton motion. It noted that there were insufficient allegations in its written
That's right,
decision.
but were there papers put in?
I'm sorry.
Were there papers that were filed? Or
You
was-
mean the defense
Yes.
files their omnibus motion?
Right.
The omnibus motion sought, they sought to litigate the issue of Peyton.
Yes.
Their argument in the omnibus motion was he was arrested inside the house.
But presumably, you could have raised attenuation in your response papers or before the court, I assume. Why should you not have put that in?
So let me answer for myself. I'll answer first for the prosecutor, and I'll answer for myself. The allegations in defense motion was he was arrested inside the house. The prosecutor said, no, he wasn't. He was arrested outside the house. Had the defendant made the motion in his motion papers that he was constructively arrested inside his house, then the prosecutor would have been triggered to say, assuming that to be true, then the fruits of this of the any legal evidence were attenuated from the illegality of that
So
search.
your argument is that it wasn't presented and therefore you raised it at the first possible time?
Correct. And when you looked at it, when you look at it as sort of as an academic question, the defendant's arguing now, the defendant argued at the Fourth Department, and the defendant arguing now that he was constructively arrested inside the house. Had he litigated that issue, then yeah, we would have been prompted to say, okay, well, that conceivably could be true, then we're going to argue
So
attenuation.
constructive arrest in the house wasn't raised at the hearing either?
It was raised in the motion. The judge, prior to the beginning of the hearing, said the purposes of this hearing are to litigate issues of standing and suppression.
Wait, I thought you said that the original motion was strictly based on that he was arrested in the house. And that
Correct.
constructive arrest wasn't part of the argument.
Correct. But there was also, they also raised the issue that he had standing to challenge the search of the premises. So you can theoretically, let's say none of that stuff happened with respect to let's say there was just one police officer standing on the threshold, knocks on the door, defendant walks out, he gets arrested. So no Peyton violation, period. Theoretically, he can assert standing for the
Right.
search of the house. So those are
He
two
could challenge the
separate-
voluntariness of the consent. Right.
Correct. And so those theoretically are two separate questions. They become related had he been arrested inside the house. But when the issue was presented to the hearing court looked at the allegations in the motion papers and simply made the determination these were insufficient. We're only going to litigate the issue whether you had standing to contest the search of the house and the propriety of the search in the
So
house
to
and
my
the voluntariness
question,
of the consent.
the issue of constructive arrest in the house was not litigated at the hearing.
It wasn't in the motion papers. The judge, I'm going to answer that, I promise you. It wasn't in the motion papers. The judge limited the scope of the hearing. The defendant started making arguments during the hearing, but the written decision said that was summarily denied. So not only was it not raised in the motion papers, although it was litigated at the hearing, the court's decision said that had been summarily denied.
On the papers, right, to make
Yes.
sure I'm looking at the right piece of paper, I'm looking at defendant's renewed motion dated April 26, 2019. It's page 144 of the record,
Yes.
I think. Okay. And so paragraph 43 says, on information and belief, gives the date, officers ordered the defendant to exit his temporary domicile and arrested him. That suggests to me that's a constructive arrest allegation, no?
But then they went on to say he was arrested inside I believe they then say that he was arrested inside the house. So,
But what I just read to you does suggest constructive arrest, doesn't it? Paragraph 43?
only in that scenario, only if he did walk out, but I believe.
It says, ordered the defendant to exit his temporary domicile and arrested him.
But then they then allege he was arrested inside the house. I believe it's the following page on 145. And if I'm wrong, I apologize.
Well, paragraph 49 says the defendant's warrantless arrest within his home was in violation of his patent rights. I'm paraphrasing there. I guess you'd have to read warrantless arrest within his home as meaning literally within his home and not as instead, shorthand for what a patent violation is, including a
that's-
constructive arrest.
But that's what the hearing court read. So even assuming,
Well, the hearing court presumably read paragraph 43 also.
yes, and even assuming if that was enough for him to
Uh-huh.
put the issue in question,
Uh-huh.
the hearing court did not grant the hearing. So the relief that was required at the appellate division was not to litigate the issue. It was to remand.
Right, but you filed a response on May 3rd, right?
Correct.
And presumably, if you understood the defendant to be putting a constructive arrest at issue, you could have, and I would guess maybe would have, raised an attenuation argument, yes?
Presuming that, and I was not the prosecutor.
I didn't mean
No,
you
and
particularly, I mean the office.
Yes, I appreciate that. But I am assuming that the prosecutor didn't read it that way either. He read it the same way as the court did, which
Okay.
is why the court summarily denied it. So even if the defendant put it in issue, the remedy is not for the court. The remedy wasn't for the appellate division to decide it. The remedy for this court's not for this court to decide it. The remedy was a remittal for a hearing on whether he was arrested inside the house, and that didn't happen. That wasn't what the defendant sought at the appellate division, and it's not what the defendant is seeking here. So that's really, when we talk about attenuation, that's why it's, yes, I didn't argue, the prosecutor didn't argue attenuation in the motion. I didn't argue attenuation at the appellate division either. The appellate division
can I
reached
ask-
this question in its interest of justice jurisdiction, which is greater than yours.
Right.
Presumably.
On the appellate division, it looked to me like perhaps the appellate division maybe transposed the standards for voluntariness and attenuation. It said that it was analyzing and deciding that the consent was voluntary, but it looks to me like the factors that were applied were the ones that were outlined in Borges regarding attenuation, not the Gonzalez factors on voluntariness.
And I believe that's what the dissent pointed out
Yeah,
as
so-
well. that-
So what do we make of that? Why isn't that something that we should send back for them to sort out so that there's a voluntariness determination that's made pursuant to the proper factors?
Ultimately, you can always begin with the trial court, because that's where your jurisdiction emanates from. Trial court did decide voluntariness on the correct factors.
But I take it you're not disagreeing with the dissent's characterization of the analysis that in the majority opinion?
It seemed confusing to me, and I will admit that. It was confusing to me, because it was also, and after the decision was made, and then there was leave, it was apparent to me that the court shouldn't have decided the issue of attenuation at all, or the issue of patent at all, because of that. And so I would say that decision is very confusing for a number of reasons. So, but in terms of attenuation, do you want to talk about attenuation? Because that's kind of how this all started, and I wanted to make sure I did answer that question
Sure.
ultimately. So there was a discussion about third-party consent, right? And I would point the court, as I did in my brief, to the Fernandez case in the Supreme Court. Someone who is not the subject of the police action, which is the homeowner or the apartment owner in this case, should be free to give consent, regardless of whether there is some sort of patent violation with somebody else, in this case the defendant, because they want to get dangerous contraband out of their home, or they don't want to be associated with somebody who's subject of criminal activity. And as
Well, why can't those be examined under, sorry. right in
Well, there
front-
you are.
Yes, here I am.
Sorry.
Why can't those be examined under a attenuation analysis? Those factors?
I don't think that I'm going to say this negatively, I mean it positively. I think you can, right? I think you can do it. But I think that desire is a big intervening factor. And to me, it's an outcome determinative intervening factor that this particular individual who had very little connection to the defendant, and I talked about standing. I imagine you probably don't want to talk about standing. It's in my brief. No one's brought up standing. I'm not going to bring up standing. That being said, when you look at the relationship between these two people, this isn't a boyfriend-girlfriend. This isn't a husband-wife. This isn't father-son or mother-daughter. These are casual acquaintances.
So it sounds like you're, in addition to responding yes, going through the factors of attenuation.
I'm sorry?
Are you going through the factors of
Yes, yes,
attenuation
I'm
or
going-
voluntariness?
I'm going to go to the factors of attenuation and voluntariness. So I guess,
I mean, but do those have to be connected? Why can't they exist on parallel terms, attenuation and voluntariness? And why can't the appellate division decide that they're going to decide this case on voluntariness? I'm going to push back on you a little bit on that, because I think the AD said, I'm reading from 1185, the tenant testified for the prosecution she voluntarily consented to the search out of a desire to have the gun removed. The tenant never claimed that her consent to search was anything but voluntary. We reject defendant's contention that the tenant's testimony is unworthy of belief. We thus conclude that the court properly refused to suppress a gun. So I feel like they're deciding this on voluntariness. Do you disagree with your colleague's assertion that Borges says you have to do both? It's a two-part test, attenuation and voluntariness, or can you just decide this case on voluntariness?
only if the, and that was one of the other issues that I don't think is preserved, because the argument that the consent was procured as a result of the patent violation isn't accurate, because the consent didn't come from the defendant. The consent came from the third party. So I think you can only look at it in terms of voluntariness and not attenuation, because you don't have that scenario. You don't have the scenario.
There are a number of federal cases I saw which, without a whole lot of analysis, but which treat a patent violation as to a defendant as having equal force with regard to some third party who's providing consent. You know, usually somebody else who is in the house. So why is that not correct? Why do you say that it's only voluntariness and not attenuation because of the third party component here?
Well, because of the fact that when a defendant is making a motion and arguing for the illegality of something, he can only assert his own constitutional violations. He cannot assert a third party's constitutional violations.
Well, I'm not sure that, you know, a third party could make a claim as to a patent violation as to them. I think the question is, you know, what flows from a patent violation as to the defendant.
Correct, but that's my point. Like, how can...
But
how
why
can-
doesn't it, I guess, is what I'm asking.
Because the defendant can't assert the constitutional, and I think I said this already, so I apologize. A defendant can't assert, because the defendant can't assert the constitutional violations of a third party, then any third party's...
So the federal cases that treat it differently are wrongly decided? in
I
your
would
view?
say without more in-depth analysis or guidance from the Supreme Court, I would have to say that, that they should be treated differently.
Just shifting gears for a minute, can I ask if we were to disagree with you and conclude, you know, at the end of whatever analysis, that the gun should have been suppressed? I read your briefs as not suggesting that as to the CPW count specifically, that there's a harmlessness error. Am I right about that?
So there were nine total counts for which he
Yes.
was convicted. The last count, count 9,
Yeah.
related to his possession of the
That's the
firearm.
CPW count, yes.
Yes,
Yeah.
CPW on the date of the
Yes.
search. That one clearly is not harmless error.
I understand you're arguing harmlessness as to the others, but not as to that specific one.
Certainly not, because
Thank you.
again, that was the primary and only evidence of possession of the weapon that particular day. So if I'm wrong on, I guess, everything in that scenario. And in terms of your harmless error analysis, the rest of the counts, because the rest of the counts pertain to the two murder ones and the criminal possession, the assault one and the criminal possession of a weapon occurring on the day of the shooting. There's more than ample proof absent the gun of those. And if there are no other questions, my time is up.
Thank you.
I'd like to also address harmlessness, but before getting there, I want to just dig into the record a little bit to talk about what's presented in this case and why the people's failure to argue attenuation becomes determinative. Besides paragraph 43 from the renewed motion, looking at the argument after the hearing, it starts with, on page 711 to 712 of the appendix, defense counsel's oral summation saying it wasn't optional that Mr. Shaw leave the residence, he didn't walk out there, our RPD didn't ask politely, and that's an arrest under Payton. That's where the defendant starts. The people respond to that on the merits. In the people's post-hearing argument, they do not say, Your Honor, there was no Payton hearing. Instead, they argue it on the merits, and they waive that issue. Specifically,
You're at 711 to 712 of the record?
that's defense counsel's argument. And then looking at the people's argument, going to page 718, the trial ADA says, the testimony that you have is credible. He voluntarily walked out. Was it in response to being ordered out? Perhaps. Was it a bad choice for him? Perhaps. Does that mean there's a Payton issue? There does not. So the people responded to the Payton, the constructive Payton violation on the merits, and I think they waived their contention through that argument that this wasn't decided by the trial court. And then I do want to focus on something that I didn't highlight in my brief, and that's on page 720 of the appendix. It's defense counsel's rebuttal to the people's argument.
But
And he-
counsel, I'm sorry, if they waived an attenuation argument at the hearing court and the appellate division reached it, they can do that, right? The appellate division could reach an attenuation argument, no?
They cannot, not where the people have not preserved the issue.
They can never reach it?
No, it was unpreserved, it was undecided by the trial court, and because it's unpreserved, there is nothing to remit for under LaFontaine. And that's why I think if this court agrees there's a Fourth Amendment violation, and if this court agrees that the people failed to preserve an exception to the exclusionary rule, the next inquiry is simply harmless error.
Do you want to address your adversary's argument that attenuation doesn't apply because of the third-party aspect?
I think that that's a novel rule that people are advocating, that just per se, a third party's consent can never be considered under an attenuation analysis.
But do you think our cases have clearly sorted that out, or is that not something we've explored?
No, I think that's I'm going to pronounce this wrong, but Xochimilco, People versus Xochimilco, is a grandmother at the front door stepping back to consent, and that was more voluntariness, but that's a third-party consent. And then in Banks, of course, you've got two men in a car. There's a traffic infraction, a traffic stop, and they are both seized during that traffic stop, and the defendant can object under attenuation grounds as to the driver's
Still I'm
consent.
struggling with how that affects the fruit of the poisonous tree argument. Because, again, you see it with the defendant who makes a statement or gives consent, and you have to attenuate that from the violation that he's suffered. And it seems like we're merging standing here with an attenuation analysis, because he is standing clearly, it's been decided, to challenge this. But there's voluntary consent given by someone else, and to the extent that consent is affected by the Payton violation in terms of the facts, I understand that. You know, he was handcuffed, I saw this person arrested in front of me and taken from my house. All that to me would go to, was it a voluntary consent? But I don't understand what line in the fruit of the poisonous tree analysis we're trying to sever here. Because, yes, you have standing to challenge it, but it isn't the fruit of your illegal arrest.
So I think where I would disagree is I think it often is the fruit of the illegal arrest, because part of the attenuation analysis is purpose and flagrancy. And what we see with law enforcement is that they're often affecting an arrest and purposefully going to someone else, purposefully the girlfriend, the wife, or the sister, in order to get that consent. So it is, because it's part of the law enforcement
But you said it
strategy.
would apply to a separate house down the block, that the person doesn't even know the arrest is going on.
And, you know, the federal circuit courts, State versus Lane, and other state courts have done this analysis, and I think that it's like evidence. It doesn't go to admissibility, it goes to weight. The people would like to turn it into a per se standing
But I thought they've only
rule.
done that in a circumstance where they're in the same place.
That this court has only done that where.
No, are there other courts, I know your light's on, I'll stop, but are there other courts that have said where you have a defendant and a third party in different places, that there's an attenuation analysis that has any meaningful teeth there?
Other than Iowa, I think you mentioned Iowa.
I think the Second Circuit's decision in United States versus, it's not Snipe, Valentine, where a defendant is illegally arrested on the street close by to the entrance to his apartment, and the police go up the stairs to the apartment and they elicit consent from the wife who's
But
up there.
that's the same location, right? I mean, the same,
I mean, he was arrested on the street, so it is a close location, but it is not the same location.
Does the wife know about the arrest?
I believe in Valentine, the wife is aware of the arrest at that point, and the Second Circuit in the Valentine decision actually remits. They say we need to analyze attenuation, and they remit for that consideration. They don't decide it themselves. I'll touch briefly on harmlessness, just to say that a homicide prosecution where there's a murder weapon in evidence is a lot different from a homicide prosecution where there's not a murder weapon in evidence. The people set up their trial strategy to emphasize the forensic evidence in this case. Mr. Hopful was the last witness, and he came in and testified that he had identified that these bullets recovered at the scene were fired from the gun.
But with respect to harmlessness, you do consider what the other evidence was or wasn't, correct?
Absolutely. I think that there's just a reasonable possibility of a different verdict
Well,
in
you've
this
got
case.
the two eyewitnesses, you've got, if I'm remembering correctly, the print, and you've got the casings, the print on the magazine from a different location, and the casings from the bullets.
But the casings from the bullets lose evidentiary value when the weapon itself is not in evidence, because they're just casings at that point. And, you know, while I don't think there's overwhelming
I'm
evidence,
misremembering the record, there's not a fingerprint of his on the casing?
there is a palm print on a magazine left at the scene. You know, and even if
that's the
this
magazine, yeah.
court determined that the evidence was overwhelming, kind of reaching the second step in harmlessness, there's a reasonable possibility that a jury, without the murder weapon in evidence, without all that supporting forensic evidence that showed that this, as the people argued in their closing, this was the weapon that committed the murders at 670 Thurston, that is powerful. That's powerful evidence for a jury, and without it, I don't think you could say that we'd have the same
Even
verdict.
with identification evidence? Eyewitness identification?
So there are two eyewitnesses in this case, and you know, when those eyewitnesses are corroborated by strong forensic evidence, it's pretty hard to attack them. But they're not the strongest eyewitnesses. They're not the weakest eyewitnesses. I would concede that.
Didn't one say she knew him for a period?
She was familiar with him from the neighborhood. But again, with that witness's testimony, she has just suffered a traumatic injury when she sees him, and not questioning her credibility, but simply her ability to recall what was happening in that moment. A lot of her testimony was inconsistent, saying that he was in front of her when the evidence showed that he would have been to the side of her. So an eyewitness like her, defense counsel.
Whether she knew him would be the dispositive and could identify him as the perpetrator of the harm that she suffered was for the jury to determine. And if she said she knew him as opposed to she'd never seen him before, those are factors for the fact finder, right?
Certainly, and I just think that
And there's another witness.
the credibility of both Mr. White and Ms. Nunez was really more up for grabs in a trial where their testimony is not corroborated by very strong forensic evidence. And that's why I think that though there's two eyewitnesses and there's the palm print.
The palm print doesn't put him at the scene?
It doesn't,
Connecting him to a weapon?
it's difficult evidence, but I think that still taking the murder weapon out of this prosecution just answering the question, is a constitutional harmless error, so is there a reasonable possibility that this affected the jury's verdict? And I think when you take the murder weapon away from a homicide prosecution, there is a reasonable possibility.
Thank you.
Thank you.